Administrative agencies. We are now going to look at our third source of law. We've looked at the Constitution. We've looked at an example of a federal statute. Now we're going to look at administrative law. Where does administrative law come from? Administrative agencies. I'd like you to take a second and look at this page of the logos of different various administrative agencies. This is just a sliver of the agencies. We've got the Occupational Safety and Health, the Fish and Wildlife Service, the United States Department of Agriculture, the Department of Commerce, Department of Defense, the Department of Transportation, U.S. Immigration and Customs Office, Homeland Security, the Environmental Protection Agency, the FDA, the Federal Trade Commission. The list goes on and on. There are a plethora of administrative agencies. This is something that really bugs some people, and I'll tell you why. And this also explains why administrative regulations permeate our entire lives. We are going to talk about the nature of administrative agencies, the different powers of the agency, which are legislative, executive, and judicial. Administrative agencies are very unique in the sense that they have been specifically carved out by our government to research and enact law within a certain sphere of authority. So we need specialized laws for certain areas. For example, the Securities Exchange Commission creates laws regulating the very complex structures of securities and bonds. We elect from our states congressmen and women who go to Washington, D.C. and make laws, but the people that we send do not necessarily have any particular knowledge of how securities and stocks work. Similarly, the people that we elect may not have any particular knowledge about what is safe for for creating regulations for food and drugs and proper testing and what kinds of items should be disclosed and what kind of trials drugs should go through before they meet the market. We vote on congressmen and women to go and make laws, but a lot of the areas that we need to have rulemaking in are areas that really require special knowledge. That is why administrative agencies were created, to have people with the expertise and training to propose laws in areas that need specialized background and training and to ensure that we get good laws. And so the more specific the area is, the more you're going to see an agency that pops up to address that area. Now, one of the reasons people don't like administrative agencies is because they are not set forth or provided for in the Constitution. So, as we talked about, if you are of a conservative view of how the Constitution should be construed, conservative in the sense that you want it to be viewed as the original framers intended, and with the historical lens of the power exercised by the federal government is only that delegated to it by the states, then people who have that sort of mindset are often concerned about the proliferation of federal agencies because this is a whole creation that's not mentioned in the Constitution. Congress and the executive decided that they needed agencies. So what they have done is they have delegated their power to these agencies. So you could follow a trail. The state governments delegated power to the federal government to govern national concerns. And then within that national government, the legislative and executive bodies have decided to further delegate some of their power to these specialized groups called agencies to implement law in a particular area. So if you don't have a problem with administrative agencies, you could take the view, well, Congress already has the power to make law in these areas. They have just decided to delegate some of their power to people who have the background and training to make better laws than they might ordinarily make. I'm personally fine with that. But that is, I just want you to understand what the landscape is as to why some people really don't like federal agencies, and they consider them, and they have that term, they're also known as bureaucracies, and there's a negative connotation a lot of times with that word, with bureaucracy. Why? So I want you to know why some people don't like them. And then I want you to understand that some people don't have a problem with them because we prefer to see people with the background, training, and expertise making laws related to, say, the environment and food and drugs, rather than just the people we elect from our states who we send there because they are popular and they make promises to us. That's sort of a political statement, but you understand this is the different landscape. Another thing that people are critical about administrative agencies is because now they're not set forth in the Constitution, and then they are have been created, and they have all three of the governmental powers vested in them: legislative, executive, and judicial. Now that can give people some pause. Even those people who have no problem with the creation of federal administrative agencies might have a problem with the fact that administrative agencies have a lot of power. They have the power to create laws, they have the power to enforce the laws that they make, and they have the power to interpret the laws that they make. And recall, when we talk about administrative laws, they're often called regulations. So they have the power to create regulations, enforce their regulations, and then interpret them. In order to balance what seems like a lot of power that's vested in agencies, they have a duty and responsibility to maintain open operations. What this means is that the public has the right to know what an administrative agency is doing, what they're working on, and have access to it via open records. In other words, the administrative agency has to keep records of their research and what they are proposing and what has been proposed, and the public can gain access to it. They have to have and conduct open meetings. So when an agency is contemplating a new regulation, they have to provide notice to the public that a hearing or meeting will be held. They have to provide an agenda of what will be discussed so that citizens can, if they choose, participate and show up at those meetings and voice their concerns. And finally, agencies have to publicly announce their intention to pass a new regulation. We're going to look at all three of these together. All of these rules that require that agencies be transparent and open are found in the Administrative Procedure Act. That, of course, is a federal law passed by Congress, which has set forth the procedures that agencies have to follow. Legislative power. Agencies are empowered via an enabling act to create regulations in a particular area. The Congressional Enabling Act that will be passed, say for the FDA, Food and Drug Administration, will state in the act what the agency's authority is. Its jurisdiction, if you will. Just like courts have areas in which they have the authority to sit and preside, agencies are created to handle specific areas, and they have to stay within that area or their charge, and that's found in the Enabling Act that created the agency. And Congress is the entity that has the power to pass that act or law that sets forth what an agency can do. In other words, the agency can't make any law outside of what the Enabling Act created them to do. To do so would be to act beyond their authority. Part of the Enabling Act sets forth what their charge is, and it provides that agencies have to follow certain steps. This is also found in the Administrative Procedure Act. An agency has to conduct research of the issue or problem that they're supposed to be addressing. They do research. That's why we have professionals. You will find in agencies that that there will be lots of, say, scientists or doctors or people with doctorates or whatever the requisite training and skill is for their area. Why? So that they can conduct research and find what is the best practice, what should we be proposing in this area. If we're going to pass a new regulation about what is safe to have in a food item, then we need to have actual research to back that up. Once the research is conducted, the agency will propose a regulation. Once a regulation is proposed, it must be made public and posted for a public comment period. In other words, the agency is going to release, these are the new regulations that we are considering as it relates to food additives, right? And these regulations are posted in two places. A book, well, it's also online now, but historically a book called the Federal Register, and in the trade journal of the industry that's affected by the proposed regulation. So if it's the FDA proposing the regulation, they're going to propose their new regulation, they're going to publish it in the Federal Register and whatever trade journals people in the food industry follow. If the proposed regulation is coming out of the SEC, and let's say it's a new regulation about disclosures and financial statements, then those proposed regulations would be posted in the Federal Register and a trade journal for accountants, like maybe some AICPA journal. So all proposed regulations must be made public and posted publicly for comment in the Federal Register and the trade journal of the affected industry. They have to stay open for at least 30 days. It can be more than that, but it can't be shorter than that. The public has the option and the ability to comment on proposed regulations. One of the things that you could do is, if you were to Google and go to some of these different administrative agencies, you would see on their websites, they will have a site, a location on their website for proposed regulations, and they'll let you know that the comment period is open and how much time is remaining, and there will be a manner in which you could submit a comment. This is part of their charge. They have to do this. It's creating the transparency. After the public submits their comments, the agency can pass or withdraw the law. Now, to pass or promulgate is to actually enact the regulation. Or if the agency receives lots of bad comments, or they receive comments from the industry that indicates this is really not a great idea, maybe we need to tweak it, maybe we need to change and reconsider, they can withdraw, they can act on that public comment and take the proposed regulations back and revise them. And that does happen at times. If the agency chooses to revise their regulation, they have to repost it and the comment period begins again. So you get another 30 days of public comment on the revised regulations. This is really important and very interesting. We don't, as a public, we don't get to do this with laws that come out of the General Congress. Or maybe I should say that differently. We could comment on laws that are coming out of General Congress, but there is no requirement and no system set up so that we could actually comment on every single law proposed and have it be read and considered by the group of legislators who are proposing it. So in some ways, you could argue this is more democratic because when an administrative agency proposes a regulation, they have to let the public know about it by publishing it in the Federal Register and the corresponding trade journal. They have to enable the public to comment for at least 30 days, and they have to actually read the comments. They don't have to act on them, but they are going to at least provide us the vehicle and review them. And they often will make revisions if the comments they receive are substantive and important and impact what they are doing. That is a real participatory process, democratic process. Why is this part of how they make law? Because we're trying to bring transparency to their process because there's so much power within an agency. But you could really argue that this is a more democratic way to make law than what our Congress does. Again, that's a political consideration, but I just want you to think about that. The executive power. So what kind of executive power does an agency exert? Well, the main way in which they act like an executive is that within the agency that has proposed a regulation, there will also be a division that is empowered to enforce the regulation, that's going to go out and make sure that when we pass regulations in OSHA about washing hands and posting signs in your stores and in your restaurants, there is a part of that agency that's going to go out and enforce, is this being done? And if it's not being done, they can levy penalties. So that in that way, they have the enforcement power. The agency has the power to investigate and determine whether or not individuals, businesses are complying with their regulations. So this is quite powerful. Now, there are limitations on administrative power, just like there are limitations on constitutional power. So let's look at those. Although the first example I have here is actually not much of a limitation. The agency that is enforcing the regulation has the ability to inspect your premises. We're thinking businesses here. So OSHA has the ability to go on site at Duke Power or at some other manufacturing company or some grocery store and inspect and find out whether or not its regulations are being complied with. And they can do this without a warrant. The agency also has the ability to compel the business or company to produce documents. Remember we talked about production of documents as it relates to discovery? Well, agencies can compel companies to produce documents to show and substantiate whether or not they're complying with government regulations. And when the government agency compels this, the company responding to it can't invoke the Fifth Amendment protection against self-incrimination. They just have to turn over the documents. That's pretty powerful. The agencies also may require periodic reports from companies, businesses, detailing how they are complying with federal statutes. Now, when we were looking at the picture on the opening presentation, that was just a smattering of all the agencies that are in force. There are agencies, especially if you consider the federal and state level, governing all kinds of conduct. If you are engaged in business, it would behoove you, you have got to have as part of your business plan to make sure that you are abreast and you are aware of what federal or state regulations govern your business. Because as we will talk about later in the course, ignorance is not a defense. If you are selling food uh, out of your little, your little mobile truck, you can't claim that you didn't know that there were safety requirements, that maybe you sterilize equipment and that the water has to be a certain temperature and that food can't sit out on a shelf for so long. There are all these different regulations generally related to try and keep the public safe, be it food or what we wear or what we consume. You have to be aware of those regulations and comply with them, because if there's an allegation that you're not complying with it, the corresponding agency has a lot of power to make you turn over whatever records you have, to allow your business to be inspected, and to have you substantiate whether or not you're following the rules. Finally, they have judicial power as well. So within that same agency, you would have a research division, you'd have an enforcement division, and then the FDA has got its administrative judges cadre. Like there'd be a group of administrative judges within the agency who will hear. It's not court, but it's sort of like court. You might think of it as what we might think of as a hearing. And they're going to hear the evidence put on by the enforcement division of the FDA about how your business did not comply with the regulations put out by the legislative division of the FDA. So their judicial power. First of all, how does an agency even know that a company or business is violating one of their regulations? A private individual could file a complaint against the business, or the agency itself could initiate an investigation, via its ability to inspect and ensure and pop up and do unexpected visits to ensure that businesses are complying. An inspector during that time frame could notice that you are out of compliance. So you could have a customer complain and file a complaint that your business is not following regulations, or the agency itself could discover it via an inspection of your premises, or maybe you weren't filing your requisite reports that were due. Any of those things could trigger a complaint. Then you would go before an administrative law judge in a hearing. At the first level of the hearing, you would appear before one administrative law judge. The administrative law judge is empowered to hear cases that relate to the infractions of the regulations put out of that agency, and only that agency. There is no right to a jury. There is no right to a jury in an agency proceeding. Why? Well, partly, and maybe really the main reason, is that if you think about why administrative agencies were created in the first place, it was to create law in a specialized area where we need specialized knowledge. So when we have allegations of violations or infractions of these special regulations, we want it to be heard by a decider who has specialized knowledge and understands the regulation. So that's why typically you have an administrative law judge. A jury of your peers is not going to necessarily know anything about FDA regulations. We quibble about this because you could also argue that's the case in any other trial, that jurors don't necessarily know anything in particular about the case they're hearing. But administrative agencies have been carved out for these very particular areas of law. And so when you have violations of the laws that they pass, it's heard before an administrative law judge. And there's one. at the first level of hearing. If you lose, you can appeal, and the appeal is that you go before the administrator. You have a second level of administrative hearings where typically there are a panel of 3 administrative law judges. Again, no right to a jury, and you're not subject to the rules of evidence. In other words, the administrative law judge can ask you to produce all the documents you have relating to the issue, and you can't keep things out on some grounds that it would incriminate you. You can't keep it out because you could, arguing it's not relevant or it's prejudicial. You can't use the same rules of evidence that we use in a regular court. What can an administrative law judge do? Typically, their rulings are they're designed to go much more quickly. They often get you to enter to things called consent decrees. It's kind of like settling, where you consent, i.e. agree to whatever is put in the document, i.e. I agree to stop what I was doing and follow the regulations, or I agree to now start abiding by Section 52 of Statute 35-21, and I will do the following things by a certain time frame. So consent decrees are when the party and the agency agree that no further action will take place on this violation, provided that the defendant, in this case, and you're not really called a defendant in the agency in this situation, but the party who's alleged of violating the regulation agrees to take certain steps. So this may or may not have any fines or anything attached to it. When you have an agency decision, the administrative law judge files an opinion, much like a regular court, and it has findings of facts and reasons for their decisions. So they act as the trier of fact and the judge of law. The administrative law judge does all of that. So they're going to set forth what they found based upon the evidence, and the evidence is everything that you presented and the agency presented. And then they're going to issue decisions of law based upon those facts. It's very detailed. They can then impose a monetary penalty, or they can just order you to stop doing what you were doing, often called a cease and desist order. We're going to talk about what the effect of is their detailed findings of the facts and decisions. What are we going to do with that? So first of all, you have to exhaust all of the administrative remedies that are available to you. In other words, if the FDA has 3 levels of administrative law judge review, then you have to go through all 3 of them. Even if you keep losing, you have to go through all 3 of them, because in the back of your mind might be, well, can I ever go to court? Can I ever appeal this? Can I challenge it? And we're going to talk about that in a second. And the first thing you have to do is, first of all, exhaust all of the remedies that the administrative agency has at your disposal. You will not be able to go to court or have outside judicial review until you have exhausted all the administrative agencies. So there's no opportunity for relief. You might suffer, financial loss during the time, so irreparable injury is possible. And even if you're finding you keep getting the result that you don't like, you still can't go to a court until you exhaust all of their levels of review. Now, once you have, and you try to appeal their findings of fact and decision in a court of law, you're still going to have some hurdles. So I want everyone to pause for a second and think, if I am a company, the FDA has brought action against me, saying that I've violated a regulation in the production of my new food product, and I have gone through all 3 levels of administrative review. I went through we appeared before a single administrative law judge, and then a panel of 3, and then I appealed it to a second panel of 3. And they keep finding against me and saying that our company is in violation. Which court would I bring my next appeal to? I can go to court after I've exhausted the administrative levels of review. What court would I bring it in? I hope everybody's thinking federal district court. Why? Because my lawsuit would be about whether or not I have violated a federal or administrative regulation. So that's part of the subset of federal laws. So I'm entitled to go to federal court. If I was bringing this lawsuit here in Greensboro, I'd be going to the Middle District Court of North Carolina, which is located right in Greensboro. Now, I'm going to have some hurdles. The courts are going to give what we call deference to the decision of the administrative agency. They are going to defer to the decision of the administrative agency. Why? Because going back to why they were created, the courts are going to reason the agency has specialized knowledge relating to this specialized law that you have violated. They are in the best position to make a decision as to whether or not your conduct violates their regulation. So they're going to give lots of deference and have a tendency not to want to review or overturn the decision. In order for you to get a court to overturn a decision of a federal agency, you're going to have one of the following things. You're going to have some procedural issue. Remember I talked about procedural law? It can help you. It can help you. If you could argue that there was some procedural law that the agency did not follow, that might open the door to get their decision overturned. Substantive law or fact issues, going to be a hard time. Why? Because if you're arguing about whether or not you actually violated the regulation and whether or not there was evidence to support that, well, the federal agency was in the best position, i.e. the administrative law judge was in the best position to make that decision. Again, a procedural question is going to be your better bet. What would be a good procedural issue to bring up? Well, this concept of ultra vires, or beyond the jurisdiction of the agency. Remember when I said that the agency can only make laws within the sphere of its enabling act? The law that created the agency, where Congress set forth what types of areas that the particular agency may create law in, kind of gave it its jurisdiction. If you, as the complainant, could say, you know what, the FDA was not empowered to make a law relating to what kinds of products go into additives for dog food. Let's say you're a dog food producer. That's outside of their purview. That's not in their enabling act. That's not in the enabling statute that Congress wrote when creating the FDA. If you can make that type of argument, you're saying that the agency lacked the jurisdiction to make the regulation that they claim you violated, then that means you might have a winning argument. Because if the agency doesn't have the authority to make the regulation, then they can't enforce it against you. So that's called ultra vires, or beyond the jurisdiction of the agency. So that's why you always, as a starting point, as the attorney for the case, you want to look and see, let's not assume that the law that the agency is trying to enforce against you is bona fide, is accurate. Let's make sure. That's your first step. Let's look at the source of law that they are using against you. Did they have the authority to create that law? All right, if they did, they had the authority. Well, did they post that regulation for the requisite 30-day comment period? Okay, they did. Well, was it posted for 30 days in the Federal Register and your trade journal for dog food manufacturers? Aha, maybe they forgot to do that. If the agency didn't post it in the places it was supposed to be posted, that would be a procedural issue that could poke a hole in their enforcement against you. Then finally, perhaps the hardest avenues to overturn it, you could argue that the finding was arbitrary and capricious. Arbitrary and capricious is a hard standard. Essentially, you are saying that the decision was, based on nothing in particular. It was just, willy-nilly. They just decided this out of thin air. It's not based upon facts. It's not based upon the evidence. It's not based upon the law. That's what arbitrary and capricious is. It's not based upon anything we can point to. That's going to be hard to prove. That's analogous to the situation where I talked about in trial court. If you're trying to appeal a decision to an appellate court and you think the jury should not have believed the evidence, and I talked about how an appellate court will not overturn the jury's determination unless there was no evidence to support it, because they won't substitute their judgment for the trier of fact. An appellate court will not overturn a jury decision unless there was no evidence to support it. If you're just trying to argue facts, and arbitrary and capricious is kind of similar to that. You're telling the court you should overturn this agency decision because there was really nothing to support it. It's hard to establish that there was no evidence to support something, that there was none, because usually there's going to be some sliver. And as long as there's a sliver of evidence, courts are going to be very reluctant to overturn an agency decision because the agencies have specialized knowledge about the regulation. And then finally, if you can claim that some constitutional right was violated by the decision of the agency, then you might be able to get the federal court to overturn the decision.